I have received earlier by email a letter from Mr. Mott's mother. At least that was the representations made to me by email. Additionally, I received an email. By the way, Ms. Mott's letter was an attached file that I did not open. I just sent it over to the state and the defense and told them that I had not read it because I wanted them to read it in the event that there was an objection to my reviewing those letters. So today, neither the state nor the defense have objected to me reviewing that letter and considering that letter. Another email letter that the court received, which I forwarded to the state and the defense, was from a lady named Christina Marra, M-A-R-R-A. That one came by way of email, so the actual email was the letter, and I have read that letter. I'm going to take a few moments to review this multi-page letter. nobody answered this case, we basically counted I agree because it was gonna be something perfunctory.
Yes, sir. We were set for a yearly review on April the 26th, but we got a letter from the hospital and they think that Mr. Holland is no longer meets the criteria for involuntary commitment. So they're proposing a conditional release. They sent a conditional release plan to the court and to the parties and also a proposed order. He is not going to be released outright. Their plan involves putting him into a facility, one of two facilities described in their proposal. I thought there was going to be an attorney here from DCF by Zoom, but it doesn't look like she's made it. But I don't think that's necessary. I think everything the court needs is before the court.
Well, which was before the court. What about the order?
I have a clean copy.
What I picked up from Ms. Overy was the Jay that is helping run this division.
Your Honor,
There were some emails related to another case of mine handled today, to my recollection.
I have a copy of their proposed order.
It's, Mr. Iganza, are you covering that case?
Yes.
All right. For the record, the court will sign the order having submitted without objection from the state. Here you go, Madam Clerk.
Your Honor, I know that they periodically report to the court. I think probably we should just set a review date sometime, either 6 months or a year away, and consider any reports that they have filed.
So 1, 2, 3, 4, 5, 6 would be August, let's say 22nd. Is that satisfactory?
This is second.
August 22nd, 9 o'clock, 6:08, for review of conditional release. I'm sure that if there are violations of the conditional release, it will be set before the court report.
Great, thank you.
Thank you, Mr. Chip.
Strike for review hearing for April 26th.
Correct, then, thank you. So now the other 9 o'clock case is Mr. Mott. So Mr. Mott, for the record, is present before the court, accompanied by Mr. Cofer, his attorney.
Your Honor, for purposes of the record, thank you for forwarding the letter from Carrie Mott, who was Logan's mother, and also the email from Christine Mara. Earlier this week, I went over and reviewed them with Logan, and I've also provided Eric Mott an opportunity to review them. My comments about both the letters, well, let me start with Carrie Mott.
Well, before you continue, because I stated that I reviewed this, but that's not the only thing I've reviewed. I've reviewed what Mr. Zicander provided to the court, which was disciplinary records from Florida State Prison, arrest and booking reports dealing with the offense that led to this violation. I also reviewed materials that you provided to the court, namely the transcript of sentencing by Judge Anderson in those proceedings during the sentencing hearing, as well as psychological reports and other materials that I'm sure Mr. Zicander received a copy of. So now, maybe.
So far as the more recent letters are concerned, I would ask that the court focus on
court, even from the psychological report that Mr. Kofer submitted to the court, which was prepared in anticipation of the sentences during the case in chief, while it was being prosecuted. I don't think I'm off base when I say that Mr. Mott is the offspring of a very acrimonious relationship that has transcended throughout the years during his upbringing, which is regretful and has nothing to do, and the court is not going to be involved in a tit for tat between former spouses. So I would note for the record that with the exception of those statements in Mr. Mott's mother's letter, it was a very insightful letter.
Your Honor, I know we presented a great deal of evidence before the hearing before the hearing, and then also during our hearing. And this case has taken a long time. There was a great deal of work done in it. I know Judge Anderson really got into his determination that the appropriate sentence in this case was the bottom end of 15-year sentence followed by 10 years probation. I think all of us hoped at that time that Logan would get the mental health counseling and the substance abuse counseling that Judge Anderson thought he would be getting. Had COVID not hit, had everything worked according to his plan, I think we may well not have been here. My concern is, and as I voiced earlier, the concept of violating somebody on a split sentence for things that happen in prison is a rare one. And doing that takes away the potential that 10 years from now, because that's what is left on his sentence, Logan will be, it removes the possibility that Logan will deal with and address those issues. It's very different violating somebody on a split sentence for things that happen when in prison versus things that happen once they're released on probation and back in the community. I have confidence that at some point Logan is going to sort all this out, deal with his depression, deal with his substance abuse, get farther removed from the acrimony that prompted him to decide that he wanted to run away while his father was out. Violating his probation now and sentencing him to what the state is asking the court to do removes that potential for rehabilitation. So I would ask the court, and I think it's within the court's power, to find that while there is a basis for finding him in violation, to continue him on probation. If he's the person that the state is saying that he is, there will be ample opportunity down the road to violate him. But don't remove the potential at this time for this young man to address the issues, because everybody who really knows him knows not just what happened and what he did on one night. Know the potential in this young man. So I would ask the court to take that approach in resolving this particular violation.
Mr. Licandro, I understand the last time we had a hearing, I passed it for a week for me to know what I was going to do. This is a very serious case. the consequences that Mr. Mott is facing is nothing to be taken lightly. And I know that last hearing, you argued to the court, or your decision was, it was not an argument, but your decision was, that the court should consider sentencing him to the 40 years that the state had, which was within the parameters of the original cap after a plea. But anything in response to Mr. Gopher?
Your Honor, I think I said most of what I wanted to say the last time,
Right.
but I would just say that at some point, and I haven't really seen this throughout this case, there's got to be some level of personal accountability, and these people clearly care about him, several people do, but I find a lot of, in their writing, everybody excuses made for him, and at some point, those excuses have to run out. It's up to him. I mean, the primary goal of criminal prosecution in the criminal justice system is punishment. And while rehabilitation is an aspect of that, it's not the primary goal. And I think that, I can't speak for Judge Anderson, but I think that you probably look at this as, look, I'm giving you a chance, and if you truly are regretful and sorry for what you did, then you wouldn't continue this behavior. And the last thing I will say is that Mr. Coker said there's this side of Logan that everyone seems to know, but there's this side of him that obviously people don't know, that he does when no one's looking. And we've seen that now manifested in the worst possible way when he committed the crime that he did, and now you've got him when he's had chances where no one's watching him, and he's continuing to break rules or commit a crime, no matter how insignificant it might seem. So I think it's the pattern of deception that most concerns the state here that I asked the court to consider. And as I stated, I mean, I asked for 40 years because that's what the state asked for originally, and I would ask that if anybody violated probation, I'd ask for the maximum just because that's what we asked for, because we thought it was appropriate then. But certainly, I think that this court, I would argue, must impose the guideline sentence of at least 21 years, and then if the court wants to continue on probation, I don't think that's a bad idea, but I do think that it needs to have the 21.25 years in prison at least, and then followed by some form of probation after the court's not inclined to just sentence him to a higher sentence that the state asked for. And I say that because I don't have a lot of trust that, and I think there's some room for supervision clearly, if the court's inclined to, not inclined just to sentence him to the amount the state originally asked for. I appreciate the court's time. Thank you.
Your Honor, if I might, I don't think that is an accurate statement of the court's obligation here. The court has to sentence him at least to the guidelines minimum.
No, I think the guidelines, between last week and now, I reviewed the Florida statutes. I think what Mr. LeCandre was saying, that the guidelines are what they are, 21.6. If the court chose to revoke and terminate and impose that sentence. I do agree that legally I have the ability to continue him on the same sentence of probation followed by the serving of the time that Judge Anderson imposed.
Your Honor, in that regard, well, his father's made a request in terms of trying to find and give the counseling to Logan, but I'll address that once the court's made the decision. He has, in the past, attempted to see if he could have an outside mental health counselor come into the prison to provide the counseling that Logan needs.
First of all, let me say that in the many years that I practiced law, before I became a judge, which was 15 criminal defense work, dealing with all sorts of cases, slight and serious. This court many times was exposed to dealing with clients, witnesses, correctional officers within the prison grounds. And this is not to belittle or minimize the actions of Mr. Mott took in making this illegal liquor or illegal alcoholic beverage in prison. And I say that because the prison officials, I for one would never, ever, I don't care how much they pay me, work in the prison. Because they have a serious job to do, thankless job to do, dangerous job to do, mainly because they have to ensure the safety of everybody within the prison walls and enforce disciplinary actions when the inmates fail to follow the rules. But I look at this case and I do not for 1 second criticize or find that the state was not doing what they needed to do in this case by bringing this case back before the court for violation of probation. Because no one should minimize, no one should look away without having some consequences for improper conduct that occurs within the prison walls, especially with somebody on probation. Having said that, a circuit judge which handled this case and sentenced a defendant to a year and a day or 13 months, whatever it was the prison sentence said, he imposed it to run concurrent with the current sentence that the defendant is serving, or that judge has the ability to impose a consecutive sentence. So I have a brother on the bench who looked at the facts of this case and came to the conclusion that within the realm of improper behavior in the Florida State Prison, the consideration of what Mr. Mott did not rise to the, at least at this current time, to the level of imposing a consecutive sentence. Which, to be honest with you, had I been that judge, I may have done am placed in a position to determine what to do with Mr. Mott's case, with the circumstances. And as I said last time, those with a substance abuse addiction are manipulators. They're selfish. They don't think about other people other than themselves. At least that has been my personal experience. Yeah, I am no expert. But at the same time, I would tell you that even though substance abuse treatment is not always successful to some people, substance abuse treatment does work with a lot of people if they want it to work. Because after all, it's their own decision. Having said that, Mr. Mott, you are going to leave my courtroom, hopefully not thinking you got away with something. And that's truly the fear that I have, just as the state has. That you may think, hey, this is just nothing. And that's the problem. Because I know the prison mentality. And if you are in that cycle, you're going to be back here before your family can do anything about it. And when you come back, you're going to have this in your record. And Mr. DeCandre is going to be around. And he's going to tell the judge what I told you today. That you're going to be institutionalized because you're going to be sentenced to 40 years in first state prison because of what you did to your grandmother. Everything that I've heard from your family members, for people that met you after you got committed this offense, from other people that have had interactions with you, I've always been supportive. I haven't heard anything from anybody that wants this court to put you in prison for 40 years. But I'm telling them, you've shot your last shot. The next time that he comes before the court, he's going to leave the court with a 40-year sentence. Because the sympathy of the justice system is not going to look at him with those eyes anymore. And that's the bottom line. I'm going to find you while under probation. However, I'm going to continue you on probation to serve. And by the way, the Florida State Prison has taken disciplinary action against him, and that's another thing that inures to his benefit, which is, at least in my mind, that they've taken game time away from him. So it's not like he's getting away with a slap on the wrist, which some people may think. But if you had come before me the second time, you would not have left this courtroom with anything less than the 21.6 years of the sentencing guidelines discussed. To be honest with you, with you, and to the state, I would tell you what I used to tell my clients. Don't take probation. Don't take the apple or the low-hanging fruit of community control. Just go ahead and take the time. Because regrettably, as a criminal defense lawyer, my experience had been that my clients could not survive probation. So to be honest with you and everybody here, so that you all understand what's going to happen in the future, he's buying himself a 40-year sentence. Because I am sure, as sure as I am sitting here, even though we all have great hope, and we all pray that he will do what he needs to do, I am telling all of you, I may not be around when this happens. He's not violating probation. And he's going to go back to prison. So, I dare you to prove me wrong. I'm going to continue on probation with the same split sentence that you received. I will not revoke and terminate your probation or your sentence. Good luck, Mr. Mott.
Your Honor, I don't know whether it'd be necessary to have an order returning him. I think the order bringing him back said to return him upon completion.
Okay, whichever order